Hello everyone, welcome to Laexcellence IAS Academy. We have discussed Article 13, 21, 26, 44, 72 and 161. Okay, next we are jumping into Article 74 as well as 163. This Article 74 and 163 deals with the Council of Ministers. And it said that there shall be a Council of Ministers at the central level to aid and advise the President. And at the state level, Article 163 deals with there shall be a Council of Ministers headed by Chief Minister to aid and advise the Governor. Here, aid and advise. This advice is binding on the President or the Governor? That is a very important question, because this Article 74 and 163 established a nominal executive as well as real executive. The nominal executive headed by the President and Governor. The real executive lies with the Council of Ministers headed by PM and CM. Right. In 42nd Constitutional Amendment Act of 1976, to the question of whether the advice tendered by the Council of Ministers is binding on the President or the Governor. In 1976, the Parliament enacted a 42nd Constitutional Amendment Act and made it that the advice tendered by the Council of Ministers is binding on the President and Governor. But in 44th Constitutional Amendment Act in 1978, this clause is removed, and in this 44th Constitutional Amendment Act, the Parliament gave the power to the President as well as the Governor to resend the advice tendered by the Council of Ministers for the reconsideration. Even in Nagar case in 2016, Supreme Court had said that the discretionary of the Governor and President does not cover broad areas. The advice tendered by the Cabinet or Council of Ministers should be binding on the President and Governor. And it said that the discretionary of the President and Governor always subject to constitutional standards. The constitutional standards here is nothing but the advice tendered by the Council of Ministers. Means advice tendered by the Council of Ministers is binding on the President according to Supreme Court in Nagar case. Means the discretionary power of the President as well as Governor is subjected to constitutional standards. Constitutional standard is nothing but advice tendered by the Council of Ministers. This is clear with respect to Article 74 and 163. And next is Article 81, 82 and 170. Why we are discussing these articles? There was issue with respect to Delimitation Commission. Southern states, especially Andhra Pradesh, Karnataka, Telangana, Tamil Nadu and Kerala, urged the central government to not conduct delimitation for the next 10-15 years. Article 81 simply deals with the composition of the Lok Sabha or the House of the People. And also Article 81 says that the states should be divided, means the constituencies shall be demarcated in the states for the representation of the people of the state in the Lok Sabha. Means Article 81 deals with the composition of the Lok Sabha, means House of the People, as well as demarcating the states into territorial constituencies. And Article 82 deals with the readjustment of these constituencies in the states according to the changes happens in the population level. Means Article 82 simply says that the territorial constituencies in the states should be changed according to the population changes after every census. The Parliament should enact a law and provides to demarcation of these constituencies after every census. This gives Article 82 gives the power to the Parliament to enact Delimitation Act. This Delimitation Act gives the power to the President to appoint a Delimitation Commission. This Delimitation Commission consisting of retired Supreme Court judge, the Chief Election Commissioner and the State Election Commissioner. This 3-member body conducts delimitation after every census, and this Delimitation Commission can be helped or advised by the MPs or MLAs in the states. But opinions and views of these MPs and MLAs are not binding on the Delimitation Commission, right? And Article 170 of the Constitution simply deals with the composition of the state legislative assemblies of the states. And also it deals with the reservation with respect to scheduled castes and scheduled tribes, and territorial demarcation means there will be a constituencies in the particular states for the representation of those constituencies in the state legislative assemblies. Article 170 simply deals with the composition of legislative assemblies. Article 81 deals with the composition of Lok Sabha. But Article 82 simply deals with the Delimitation Commission, means it gives the power to the Parliament to enact a law which can provides there is a demarcation of the constituencies in every state for the representation of the people in the House of the People. Accordingly, the Parliament enacts Delimitation Commission after every census, consisting of a retired Supreme Court judge, Chief Election Commissioner and election commissioners of the states wherever there is a delimitation is ongoing. And the judgment or the work done by the Delimitation Commission is final and binding. But recently Supreme Court said that this judgment of the Delimitation Commission shall be or can be questioned in the court of law, because if there is any extraneous grounds are considered by the Delimitation Commission, where there is a misuse of power by the Delimitation Commission, based on that there can be a petition or the challenge can be made in any court of law with respect to judgment of the Delimitation Commission. And this Article 82 has been amended 3 times. 42nd Constitutional Amendment Act, which frozen the seats based on 1971 census. Again in 2001 through 84th Constitutional Amendment Act, which allowed the readjustment of the constituencies without changing the composition or the number of seats in the Lok Sabha. Again in 2003 through 87th Constitutional Amendment Act, the seats in the Lok Sabha again frozen based on 2001 census. These with respect to Article 81, 82 and 170. And again Article 87 and 175. Article 87 and 175 deals with a special address by the President and Governor. Why we are discussing this? Recently, Tamil Nadu Governor R.N. Ravi walked out of the session, the special address, because there is a issue of national anthem. And because of this, we will discuss Article 75 and 87. Article 86 as well as 174 also deals with the President and Governor addressing the sessions of the Lok Sabha or the Parliament or the state legislature. But Article 87 and 175 particularly deals with a special address by the President and Governor. This special address happens 2 times. One, every year in the fresh year, the first session of the Parliament addressed by the President at the central level and the Governor at the state level. And also after every election, when there will be a constitution of the fresh Parliament, means the fresh Lok Sabha, at the state legislative assembly at the state level. Then also governor and president addresses both the houses. These deals with Article 87 and 175. And with respect to these cases, in Shamsher Singh versus State of Punjab, Supreme Court has said that the president and the governor are guided by the cabinet. Means the president and the governor shall convene session based on the advice or the recommendations of the cabinet or the council of ministers. It relates to addressing the house or return the bill for the reconsideration. These shall be considered, means the advice tendered by the cabinet or the council of ministers shall be followed by the governor and the president. With respect to the Article 87 and 175, Supreme Court said in Shamsher Singh versus Punjab case. Okay, hope you understand what is Article 87 and 175. Thank you.